Hello and welcome back to Take from Caesar. Glad to have you. The purposes of this video are served in really short order. It's about the exchange of briefs you saw in the 30th anniversary video here on Take from Caesar, posted on April 15th of 2018. The exchange of briefs was between yours truly. I wrote the briefing. They're my conclusions from my 1994 treatise called Codebreaker, about the perfections of the tax code. If you honor the way it reads, it sings for you in ways the government can't refute. That's the main thing. My name is David Merlin. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Believe it. Here's more proof of it. Now, in the 30th anniversary video, it concluded with the offer to penalize the man. The case is over and we should penalize you. Well, actually, I think it was predicted in the 30th anniversary video that he would lose. Of course, because this isn't my first bar mitzvah. It's exactly what they pulled in the 1990s in 5 trips to the Supreme Court. It's why I went into mostly studying state law and trying to help people there on that front. And what ultimately happened was, from the 30th anniversary video, the exchange of briefs, the court issued an order thereafter, a non-precedential order, meaning don't quote me, and said, your case is over. It's all outlandish theories. All of your arguments are outlandish theories. And we want to hear from you back as to why we shouldn't penalize you. And so I spoke with him, and he agreed that, yeah, man, that's mail fraud. I'm entitled to an explanation of the laws. I can't get it. I can't have access to these provisions. And so he wrote back, or I wrote up a federal criminal complaint to his liking, an affidavit for him that was in fact an accusation of crime, which is not illegal. You're supposed to file criminal reports under 18 U.S.C. 4. If you know of felony violations of the law, you better report them, pal. You know they'll lie you right into prison. Why wouldn't they say you failed to report this crime? Well, because a public servant committed it, and so they think, of course he committed it. What's your problem, citizen breath? So, mail fraud, they're threatening to penalize me. They accepted a $500 penalty from me. And we're going to get into all this, however briefly, because it's all on the web. I'll show you the web page. And he filed a criminal complaint for conspiracy against his rights to property in the form of those monetary sanctions, and for mail fraud. They're using the mail to do it, and named in the criminal complaint 3 judges on the 7th Circuit. One of them is the chief judge, Diane P. Wood. The other 2 are judges, Diane S. Sykes and Joel M. Flaum. They're the named defendants in his criminal complaint for mail fraud and conspiracy against rights. And then attached all that to his reply back to the court saying, I don't think there's anything I could say in the world that would keep you from penalizing me. Look what you're doing. It was so over the top, I had to complain to the FBI. In this complaint to the FBI, he tells them, if they impose these penalties, why don't you just count me in for having accused them of extortion also, because all I argued was the law. And in their reply brief in the 30th anniversary video, you see that 85% of the provisions relied upon, they couldn't even mention. The controlling provisions, the really core operable law determining the scope of the statutes, whether or not a statute can deviate from regulation. They just said outlandish theories. Well, they've had the arguments for over 25 years. And yet, they can't produce one single decision from a court that gets into the language of the statutes relied upon. One court, Talmadge versus Commissioner, 1995, that tax court decision got into the reasons it feels Section 83 does not operate the way I've briefed it. And earlier in this same case that we're going to get to, this same case, when you see the, he cites the Talmadge decision in his opening brief. And then in their reply brief, they say, yeah, that's still the same standard in the case that he cited. Instead of citing Talmadge versus Commissioner, they just said, yeah, we agree with him about that case. They don't want to mention Talmadge. That 30th anniversary video is dynamite. Now, take from Caesar, a little bit of publicity here. Take from Caesar. I look at this channel, and this is a curriculum, especially my earliest videos. The first 20 videos are dynamite. One viewer early on comments in one of the windows you'll see on one of these videos, I've had to totally change the way I look at law because of you. Thanks, man. That's what I'm here for. I do everything in the box, but I've put together certain pieces that when you combine them, it's like, you know, certain compounds. They don't look like much, but you put them together and you might blow the roof off of your house. So I look for the things that are aggressive, and I don't have anything to offer the guilty person. Take from Caesar. I just really like the appearance of this channel and the content. It's really hard-hitting, and it does a lot for especially somebody polluted and corrupted by the Patriot movement, anti-tax movement, or whatever. I use the leverage of the law, because I found so many protections. I use the leverage of the law to prove public servants are committing crimes. If you can arrest a felon, who wouldn't want to prove that a public servant's a felon? Instead of just taking the grief on that they like to visit on people, you know, be somebody, stand up to them. That's what I provide. TalkShoe 59615. Data, that's my TalkShoe handle. And here's my archive. A whole bunch of lessons there also. Wonderful lessons. Most of them are lessons, particular aspects of law. I don't record every call that I do there. I just record calls that feature a particular lesson that I want to convey. Hope you enjoy that. TheBookPatch.com, the bookstore. Search the bookstore. My last name, Myrland. Search by author. And here I go, TheBookPatch.com. And here's my page, Hybertson versus U.S. You watch the exchanges between me and government attorneys. Back and forth, back and forth. They can't come to the table about these arguments. I'm giving you examples of how the government fails with these particular arguments when they're comprised totally of statute. In the Social Security argument is a slam dunk. I've got a mountain of statutory proof that the scheme was never intended to apply to citizens of the United States. A mountain of evidence. No confidence, Civil Liberties versus Homeland Security. You got to get this book. Over 110 statutes I've written, and maybe a dozen proposed constitutional amendments. Just a fantastic view of law. From the other side. What laws would you like to see in place? What's your problem? Quit whining. What law do you need to correct that? Okay, do you have initiatives in your state that you could ballot access for referendums, initiatives, whatever? It's not the same in every state, but there's going to be a bunch of people that have already done it, and if you want to try to bankroll a particular law that you'd like to see in place, more power to you. But there's an expose on the length to which I took that notion. Public vehicular travel. This is the criminal complaint Kurt Riggin and I filed with the Department of Homeland Security and the Department of Justice. I'm sorry, not the Department of Homeland Security. The Homeland Security Committee in Congress and the Department of Justice on March 9th of 2006 that explains how to research the Motor Vehicle Code to prove it was never written to apply to others on the highway, people other than those using the highways for place of business. Take from Caesar, Volumes 1 and 2. Volume 1, Complaint to 80 Members of Congress, January of 2006. Volume 2, the supplementary complaint, or supplementary memorandum, filed August of 2014. Codebreaker, the Section 83 equation. I'm the only one on the planet that teaches this statute. It explains how to tax the entire workforce. You have to get this book. It's a desk reference manual about the language of Section 83 and its implementing regulations. To POTUS.com, I filed a criminal complaint with the President on Inauguration Day that has these findings briefed in it to complain that here's the racketeering scheme right here. And these are linked from wevgov.com, wevgov.com, which coincidentally is right here. Can you believe it? So wevgov.com, this is the site as it was last October, and I'm preserving it as it is right there, snapshot. And I will have a new site coming soon for content. So because they called this a tax protester website, and because the law is an outlandish theory, I wanted to take a snapshot. This is the way this website stood when they said it's a tax protester website. I'm not going to amend it. I'm going to move on and focus on the judiciary for what they did, and we're about to review that. 'Tis a riot. Now, I don't have it linked yet. I kind of cart before the horse. I should have amended this page to include the link to the tax court table of authorities, but when you see this video, it'll be up here somewhere. Tax court table of authorities. It'll be on this page. Proof on the 7th Circuit. That was the topic in the 30th anniversary video, wasn't it? And the tax court table of authorities, actually this is on appeal, I think. This is on the 7th Circuit. This was in his table of authorities for his appellate brief. This is the kind of review he's seeking. And here's a law that says courts are supposed to do this under the Administrative Procedures Act. True, he's not under the Administrative Procedures Act, but this sounds like just what a court should do. To the extent necessary to decision and when presented, the reviewing court shall decide all relevant questions of law, kind of like doing your job. Interpret constitutional and statutory provisions and determine the meaning or applicability of the terms of an agency action. The reviewing court shall hold unlawful and set aside agency actions, findings, and conclusions that are arbitrary, capricious, an abuse of discretion, or not in accordance with law, or contrary to constitutional right, power, privilege, or immunity, or in excess of statutory jurisdiction authority. We did all this, and they won't talk to you about it. So they're the opposite of this in how they deal with these issues. And yeah, I'm steamed about it. I'm still plenty steamed about it. And this is all gone through in the 30th anniversary video, okay? But I just wanted to remind you, because you've already seen that. You've watched Key to the Code video. You've watched the Section 83A tutorial. And here on page 12 of his table of authorities and contents, the text of every statute relied upon, every statute or regulation relied upon in the briefing of these key arguments. Section 1 is many pages long. Please don't read it. It'll make the eyes in your head roll back. Section 1 of the tax code, the graduated income tax. If something's that long, they're trying to distract you. Period. 61A, gross income except as otherwise provided. 61B says, for items specifically included, see Section 83. Okay, so that's otherwise provided, isn't it? It's an exception. Isn't that easy? Now, it's a matter of putting the right things in the right places. Okay? It's that was one of the hardest things about this, was the research, of course. But then to take all of that research and throw away 95% of it to concentrate on these 45 provisions. That's the difference, is being able to make sense of all the research. I did the work. I did more work than really anybody else except Lowell B. Craft and others that have studied his research. But as far as cutting-edge research, I'm the one that made sense of the tax code using the tools the government says you have to use. I did it the hard way. So see Section 83, only the excess over the amount paid is gross income. 212, the individual gets a deduction. 879A2, a non-resident alien to Chapter 1 goes to Chapter 2 to figure the tax. On and on. These are provisions they didn't even mention in rebuttal. These, right here, 1001, 11, and 12, they control. They didn't even mention those. A regulation under Section 83, 1.83-4B2, says to use Section 1012 to figure your cost. They don't have a choice, and they didn't even mention it. Social Security, self-employed, Chapter 2. Chapter 21, FICA. Chapter 33, matching FICA by employers, an excise on them. 6001, if you don't have gross income, you don't have to keep records or file tax returns. 6011, 6012. 7201, tax evasion. You have to owe the tax before they can get you. 7345, we're going to take your passport. Articles out now everywhere. 362,000 people are going to have their passport privileges suspended because their existing tax controversy exceeds $50,000. What a pack of vultures. They can't even prove you owe the tax. These provisions are off limits. Here's one right here, 7655, says that Social Security applies to the possessions. Yeah, how about that? This is the one that says that Chapters 2 and 21 come from Section 3811 of the Internal Revenue Code of 1939. Collection of taxes in Puerto Rico and the Virgin Islands. A, Puerto Rico. B, Virgin Islands. Oh no, we can't talk about that. 7801, the Secretary can write regulations. 7805, in charge of the enforcement of the code, he's ground zero. And so we go by the regulations and we find all these protections. They won't talk about them. Here's 3811, collection of taxes in Puerto Rico and the Virgin Islands. In 1954, when they rewrote the 39 code, they split this statute up into Chapters 2 and 21. Okay, and here's more. They mentioned this, didn't get into any of the language of it, because it leads to those 5 decisions they won in the Supreme Court that says any is all-inclusive. They can't afford that. Here's -4B2 that says you apply Section 1012 to figure your cost. They don't have a choice. 1001 says the amount, let's see, which contemplates, right here, which contemplates that from the amount realized upon the sale or exchange of property, there shall be withdrawn a sum sufficient to restore the adjusted basis prescribed as Section 1011, which is the 1012 basis, and the regulations thereunder. Let's see. The amount which remains after the adjusted basis has been restored to the taxpayer constitutes a realized gain. Can't talk about it. Didn't mention it. Didn't mention this one either. The implementing regulation for that funky definition of citizen in 1402B. So I kicked his ass, this opposing attorney. Who is this opposing attorney? Richard E. Zuckerman, Principal Deputy Assistant Attorney General for the United States of America. And in the 30th anniversary video, you see I kicked his ass. The galaxy's finest tax attorney. Can't even talk about the controlling provisions. So we go to that case, and here you'll see the exchange of briefs on the 7th Circuit that you saw in the 30th anniversary video. Right here it says YouTube tutorial for this page. Right here, I'm going to put the link for my YouTube tutorial that I'm making right now, right there. You can donate to American Liberties there at PayPal. Here's the 30th anniversary video, link right here. And important, this page is premised upon your familiarity with the work on wevgov.com that I preserved relating to federal income taxation, federal criminal statutes, state income taxes, and the right to arrest a felon. Not legal advice. In fact, here's your proof that the law doesn't matter, so there's no such thing as legal advice. Just arguing the controlling law got this American skewered in the form of enormous fines for frivolity. You do what the judges tell you to do. That's legal advice. Now, here's another link to the exchange of briefs, the 30th anniversary video. And you could read this at your leisure, but to underscore this, It's because of the judges you pay. It's not because of the law. The buck stops with the court. It's their job to say what the law is. And in this instance, they won't, because the law hurts. It's the truth. The truth hurts. This is the opening brief from the appellant on the Seventh Circuit. And here's the brief that you saw in the 30th anniversary video. These are the issues that it argues. And the court said they're outlandish theories. They've had the arguments for 25 years and can't even answer. The court knows that the briefing is correct and valid. It's a racketeering scheme, and they aren't going to talk about it. And they're trying to give everybody the understanding these provisions of the law are off limits in America. And so far, it's true. They don't even have an interpretation of them. Well, aren't they supposed to follow the law in every instance? Yes. That's why the law is there. It binds everybody. And I've discovered how they're violating the law. And so they don't talk about the provisions that prove it. It's that easy, that plain. And you can pause this anytime you want to read this. Go to the web and look it up. Okay, wevgov.com, proof on the Seventh Circuit. Click on that link and bingo. Here are the provisions relied upon. What's the problem? This is all law. This is pure law. The arguments are purely law. Period. End of story. And they can't. The only thing they can do is say outlandish theories, and we think we should penalize you. What do you say? Well, if you want to face a count of extortion, nothing can stop you now. You're on a roll. I'm not stupid. I'm not getting in the way of a bunch of people so corrupt they're going to outlaw a legal argument about controlling provisions. Answer from the Commissioner of IRS. And it's from Richard E. Zuckerman, the principal deputy assistant of the Galaxy. And the reply pointing out, he doesn't know what he's talking about, Your Honors. It's farce and folly when it's not outright deception. Yeah. And here's the decision that you did not get in the 30th anniversary video. It had not yet been rendered. And right here, in writing, non-precedential disposition of the case. They disposed of the case. To be cited in accordance with this rule only. And that rule says, you know, we really should just go out and shoot these people. I have no idea what that rule says specifically. Who cares? I'm arguing just the law. I shouldn't have to care. Chief Judge Diane P. Wood, Diana Sykes, Joel M. Flown. And let's see. He reserved him for appeal. That's right. And tax court didn't deny that, yeah, we'll penalize him. His outlandish theories challenging the legality of the tax code. Where did he do that? Nobody challenged the legality of the tax code. He's challenging the validity of the determination that he owes that tax. The tax code, fine. It applies where Congress says it applies. And it operates the way Congress intended it to operate. It's not an outlandish theory about the legality of the tax code. We're challenging the legality of the enforcement. So they had to first totally misrepresent just so they could fit in somewhere that they've written against before to say these are frivolous tax protester arguments about statutes we can't talk about. And they go on to cite none of the statutes that he argued. None. So he filed a criminal complaint with the FBI. Mr. Orth's criminal complaint to the FBI for conspiracy and mail fraud. And here's the scanned copy with certificate of service and everything. Right there. It's not a very good copy, and so I put the draft of the letter available in a link after this link, you see. And it went to FBI agent, Special Agent Abbott, as you see, in Indianapolis. So the guy means business. I'm complaining to the FBI. All I did was argue the law, and you want to penalize me $4,000? So here's the complaint to the FBI. You can read it at your leisure, saying all I did was argue these, and it's over the top what they're going to do to me, and they're using the mail to do it. His exhibits were his Seventh Circuit appeal brief, Seventh Circuit appeal from tax court without its exhibits. So you're going to see several exhibit pages, but no exhibit between those pages. That's where I took out the exhibits to reduce the size of the document. I didn't want to lose the agent in stuff he doesn't need to know to see that it's mail fraud. B, the final opinion and notice saying they want to impose sanctions. They want to hear back from me. And Exhibit C, this is so important. This is the book on statutory interpretation. The Fourth Circuit decision in favor of the tobacco company and the Supreme Court decision in favor of the tobacco company in FDA versus Brown and Williamson Tobacco Company. Those two memorandums in one place constitute the book on statutory interpretation. It's one of my favorite books. Those two decisions under one staple. I don't have favorite books, I have favorite court cases. My favorite book ever is Edwards versus California, 1941, Supreme Court on the Rights of the Poor. Agency power is not the power to make law, rather it is the power to adopt regulations to carry into effect the will of Congress as expressed by the statute. It is the judiciary duty to say what the law is. This is for the FBI agent, telling him what I'm entitled to when I appeal. This is Security Bank of Minnesota versus Commissioner. The parties provide vastly differing interpretations of the statutory language, and as judges, we're supposed to get into it and sort out the languages and decide in favor of the one that the law favors. Not this time. Taxpayers' Bill of Rights, they are entitled to clear explanation of the law. Well, not this time. Not those laws. Not those laws, Citizen Breath. Can you hear them? Not those laws. 2001, when the taxman seeks to put his finger on the citizen, he must also put his finger on the law permitting it. Well, not this time. Not those laws. It's so easy. What we've done, we see the baton handed off from the IRS to tax court. And then tax court runs its route, and we avoided penalties by not raising these issues in tax court. And they hand the baton off to the appellate court for more of the dirty work. It started at the IRS. And here's the court's role in making sure the racketeering scheme succeeds. Not those statutes. Isn't that easy? It's exactly what you see right here. Not those statutes. Well, I only have 40 of them and 5 arguments. What's your not those statutes. Can you hear it? And on page 5, here at the bottom, I see 7214. It says, if they ask for sums other than what the law allows, they could be fired and prosecuted. Well, count me in. Can I have some of that? Oh, not with those laws. Because those are laws they can ignore. You understand. So it's not imposed by clear language, is it? That's due process. They're depriving me of due process when they keep me isolated from the law. Because I have this right. I have a right to have it imposed by clear and unequivocal language of all governing provisions. Well, not those provisions. Conspiracy against rights, 10 years max, unless it involves a kidnapping or an attempt to kidnap, then it can be up to the death penalty. See that? Extortion. He asked them in this complaint, if they impose the penalties, count me in advance for a count of extortion. Because we knew he was going to send that to the Seventh Circuit, so they knew in advance of imposing the penalties that he would accuse them of extortion for doing it. They did it. You don't matter, the law doesn't matter. And no FBI agent is ever going to arrest a judge. So you can't have the law. Do you call that a country? Is that a 4th of July to celebrate? Mail fraud. You put anything in the mail, attempting, let's see. by means of false or fraudulent pretenses, representations, or promises. Yeah, you took $500 from me to as a filing fee for my appeal when you intended to sabotage me. So this is the same court, the Seventh Circuit, in 2012, telling you that the regulation identifies the subject of the tax. You can't do that with a regulation. But when you say to the court, listen, the regulation identifies the subject of the tax, and you show them this, they call it an outlandish theory. They're so far wide open to mail fraud and conspiracy against rights on this one. And I've done a lot of thinking since I had to ponder the conduct of an appellate judge. And this conduct is over the top. Hey, it appears to me that everybody in America can arrest them. All those cases say so. Here's the Indiana law that says you can arrest a felon. And here's the Illinois law that says you can arrest anyone that's committed an offense other than an ordinance. That could be a misdemeanor under state law. Arizona has done the same thing about shoplifting. You can arrest for a misdemeanor. So here he is, all signed. And it went to that court to say, you know, you're so over the top with that threat of sanctions, I had to complain about you. And they doubled down on it because it doesn't matter. Okay? And this document's on the web, so I'm not going to cruise through the contents with you. Okay? It's a lot of it is stuff you've already seen. And here's that memorandum from the Supreme Court and from the Fourth Circuit together. You'll have them in PDF. This is the book on statutory interpretation. It's 80 pages long, 2 decisions in one place. And listen to how the tobacco company kicked the FDA's butt, saying all your authority over tobacco comes from regulation alone. There's no statute. In fact, if you had the authority to regulate tobacco, you'd have to ban the sale of tobacco tomorrow because it's a dangerous substance according to all your past opinions on tobacco, and the Food and Drug Act prohibits such products. So, no, we think Congress reserved authority over tobacco to itself. It has not yet delegated it to the FDA. And these 2 decisions are the book on statutory analysis and the authority of Congress versus the executive when it comes to writing regulations to put what Congress says into effect. It's the book on statutory interpretation. So, and I think those are highlighted in places I found relevant, most relevant. So enjoy those and take them in slowly. Take a few nights to read them and highlight the places you like, because it is the book on pleading regulation versus statute and statutory interpretation, the gravity of statute. So once again, the exchange of briefs on the Seventh Circuit. Now, the Vallone decision, I already touched on that. This writing won't be here when you see the web page. This is just for my purposes when doing this tutorial. They don't want to indulge those 5 decisions about the term any because it describes your cost as any property. Can't talk about that. Has to be imposed by clear language. It could lead to tax evasion charges. The law says the same thing every year to me. Am I supposed to go to court every year, all the way to the Supreme Court, only to be told I can't have access to the statutes I believe protect me? It could lead to tax evasion charges when all along you keep the law a secret and you want to put somebody in prison, and suspension of passport privileges. These are not, you have to spare me, okay? These are not outlandish theories. In the 1950s, a bunch of people were arbitrarily placed on Communist Party watch lists. And they took the Secretary of State all the way to the Supreme Court a couple times. Kent versus Dulles, McGrath, and Joint Anti-Fascism Network or something. There's a couple of cases that I cited in the argument. In fact, if you want, we could let's back up here and go to the opening brief, issue number 5. Okay. Okay, that's not it. All right, coming up here. Opposed by clear language. Here we go. I am not afforded the procedural due process to which I'm entitled when you suspend my passport privilege without giving me review. The Joint Anti-Fascist Refugee Committee versus McGrath, and Kent versus Dulles, and here's a couple of others. I highly suggest, pause the video if you want to read them right now. The right to be heard before you suffer an egregious loss or grievous loss. Bell versus Burson was about driver's licenses, and you can't just take them away without procedural due process required by the 14th Amendment. You can't do it. Oh, yes, we can. Not those statutes. It's all in the open now. Everything's done. This is 25 plus years they've had the arguments, 24 in litigation or after the first litigation. And the best they can do is say outlandish theories and not even mention the statutes relied upon. Their souls are toilets. And here it is all in one place. Isn't that neat? So the FBI complaint's been filed. They did follow through with penalties. He's going to appeal to the Supreme Court. Now here's the positive. They made a decision on the merits. The 9th and 11th circuits said you didn't raise them in tax court, so you can't raise them here for the first time on appeal. This guy reserved them for appeal in tax court and said, I know you'll penalize me. I'm not stupid. I'm not going to raise these arguments here. And they didn't deny it. Yeah, we'll penalize you. And so he took him to the 7th Circuit, and the 7th Circuit heard him on the merits and said it's outlandish theory, tax protester arguments. Okay, thank you. That's a decision that you are wrong. That's a decision that the parties have vastly differing interpretations of the same provisions, and that the 7th Circuit has found in favor of the government's interpretation, whatever that is. They won't share it. And so these issues are legitimately, would be legitimately brought if briefed for the Supreme Court, saying I want a decision on each of these issues and a decision on whether or not their imposition of penalties is constitutional, when all I had was statute. And none of those arguments are on the frivolous argument list, and they've had 25 years to put them there. Oh, that's a good point. So it's all done. It's a tax protester website. Well, here's the best you can do against the arguments, and I'm moving on. Because now it's about how the judges misbehave and criminal complaints against judges. We've done all the work we can with the motor vehicle code, state income tax, and income tax. Fed, they won't talk. Okay, it's useless. But are there crimes committed when they don't talk? Yeah. How about conspiracy against rights? 3 judges signed that order. That's pretty much a conspiracy. If 2 or more persons conspire, Section 241, 10 years in prison for not disclosing their interpretation of the law that differs from his. How about that? So now all of America can arrest those 3 judges. Tell me how I'm wrong. Anyway, it's something else having to do this while the law is clearly kept a secret, and while we know that if the law defeated us, they would take it out and club us with it. And when they keep a law a secret, Section 83 explains how to tax the workforce. When they have to keep a law a secret and penalize you for asking them to do their jobs. Can we draw a few conclusions from that? Yes. You're on your own. There's no such thing as legal advice. I'm not going to tell you what to think. At the bottom of the page we see how you can help. Here's a Microsoft Word blank or template that you can, if you feel after viewing all of this that he's correct in his accusation that mail fraud has been committed, you can take this Microsoft Word affidavit of joinder that has the address of the FBI that received the complaint and the address of the Second Circuit, notarize a couple originals, keep one for your files, and send an original to the court and to the FBI. Their addresses are right in the letterhead. So the judges know citizens are looking at this complaint that says everybody in the world can arrest these judges, and they're joining it as similarly situated witnesses. Tee-hee-hee, ha-ha-ha. And here's a short paragraph about my criminal complaint course, How to Write and File Citizens' Criminal Complaints, that has a bunch of wonderful Microsoft Word criminal complaints that I wrote for others over the years. I stuck a bunch of them in one course that opens up like a website on your computer. They're in Microsoft Word, so if you like them and you care to use them, they're already there, structured correctly, written impeccably, with a bunch of audio instruction in that course that comes to you on a flash drive. Highly recommended. Today, Kurt Riggin called me, just this evening, a couple hours ago, to share a testimonial that somebody, he says they wrote it on WeVGov. I don't offer a chat window on WeVGov.com. I told him it has to be on my YouTube channel, but I don't have any comments for review in my back room in YouTube, so it might take a while for them to show up, but the guy took his time to tell you product by product why you should have them. And he says you start with the criminal intent course, you go on to the criminal complaint course, then you go on to the drive-by litigation course, but you handle it like you're handling an atom bomb. Be careful with this, because it's cutting edge, ultra aggressive, and you have to know what they're able to do to retaliate against you. But if you do know, you can walk right with them. So anyway, that's going to be a testimonial from a guy named Riley. Anyway, again, my name is David Merlin. None of this is legal advice. Thanks for checking out TakeFromCaesar.com. I sure appreciate your consideration and attention, and my products are very inexpensive. My printed materials on thebookpatch.com are wonderful desk references for these topics, which are under an umbrella: IRS, illegal revenue streams, Internal Revenue Service, ignorance reaps slavery. Thanks again. I'll see you in the next tutorial.